Hi, everyone. I'm Natasha Brown, Director of Access to Justice and Community Engagement at the University of Manitoba Faculty of Law. Thank you for joining us for Manitoba's second Access to Justice Week event for 2023. Today's event, entitled Are We There Yet? Reflecting on Access to Justice Progress and the Obligation to Advance Access to Justice in Manitoba, is hosted by the Law Society of Manitoba. All of today's speakers are located on the original lands of the Anishinaabe, Cree, Ojibwe Cree, Dakota, and Dene people, and on the homeland of the Red River Métis. We respect the treaties that were made on these territories, we acknowledge the harms and mistakes of the past, and we dedicate ourselves to move forward in partnership with Indigenous communities in the spirit of reconciliation and collaboration. I would also like to acknowledge that the water we drink is from Shoal Lake 41st Nation. As we move forward with new access to justice initiatives, it's imperative that we do so bearing in mind the importance of reconciliation and decolonization. Just a bit of housekeeping before we get started. Today's webinar is scheduled for 2 hours. Audience microphones and cameras are turned off to help minimize interruptions, but the chat and the Q&A functions are both enabled for today. Use the chat to alert us of any technical issues, and please use the Q&A to submit your questions. And our plan is to address those questions at the end of the presentation. Please keep the questions for the panelists not in the chat, but in the Q&A. The theme for today's Access to Justice Week is the 10-year anniversary of Canada's Justice Development Goals. Before I turn to our panelists to discuss their reflections on this 10-year anniversary, I thought I would just take a moment to briefly explain these goals and how they came to be. In 2007, Chief Justice McLaughlin established the National Action Committee on Access to Justice in Civil and Family Matters. The committee was created to be a national network working towards improved access to justice for Canadians. The committee is currently chaired by Justice Karakatsanis, and its Manitoba representatives are myself and Stacey Soldier. 10 years ago, the committee released a seminal report on access to justice in Canada, which is entitled A Roadmap for Change. And I believe, that's just been put in the chat. So if you want to take a look at that report on your own time, please feel free. It's a good read. The report sought in part to fill the need for a coordinated and collaborative national voice on the topic of access to justice. Along with this report, the committee enumerated 9 access to justice goals, which are the justice and development goals that we're going to touch upon today. So these were address everyday legal problems, meet legal needs, make courts work better, improve family justice, work together, build capacity, innovate, analyze and learn, and finally improve funding strategies. So I just wanted to quickly share my screen. So the website is just justicedevelopmentgoals.ca. And if you scroll down halfway through the page, you'll see the 9 goals enumerated there. Unfortunately, the website isn't the easiest to navigate, but if you click on a goal, so for example, if I click on the first goal of address everyday legal problems, if I scroll, I will then see what that goal actually entails. So educate early, prevent, offer a continuum of services, and reflect Canadian society. So each of the 9 goals has some sub-goals within it. And then for each goal, you can see where each province is at with respect to its reporting on that goal. So if we look at the first goal, if I click, I want to see what Manitoba has done with respect to address everyday legal problems within the 2022 year. This would be last year's reporting. I can then sort of scroll across and see Manitoba's work. And you can do that for each goal. They sort of set it out in different ways, how you can view the graphic. But each of the 9 goals is there. And then the sub-goals below it. So I'm just going to stop sharing. Feel free to take a look at those goals and the sub-goals below. And if your organization actually is working towards that and you would like to be included in the report for 2023, please reach out to me. And when the time comes for Manitoba to do its reporting, I can flip you the information that you need to be able to complete that for your organization. And I just see a question about, will this presentation be available by email? It'll be recorded. So once today's program is finalized, a link will be created subsequently. It'll be uploaded to our website and you can view the program in its entirety whenever you want to come back to it. So now, I should also say that the Justice Development Goals were created pre-TRC. So if you're wondering why those aren't incorporated within the 9 goals, it's because they predate them. So now I'm just going to introduce the panelists because they all play an important role in Manitoba's access to justice space. And I'm excited to welcome them here this afternoon to reflect on their organization's work to advance access to justice. First, I'd like to introduce Darcia Senft. Darcia is employed with the Law Society of Manitoba as General Counsel and Director of Policy and Ethics. Prior to that, she held a number of important roles within the Law Society. She was called to the Manitoba Bar in 1988 and to the Ontario Bar in 1993. She's been an active member of the profession, having served as a bencher of the Law Society and a non-bencher member of various committees. She's also a life council member of the Bar Association and currently the co-chair of the Federation of Law Societies Access to Legal Services Exchange Group. We also have with us Peter Kingsley, KC. Peter received his LLB from Robson Hall in 1994 and articled with Legal Aid Manitoba in Winnipeg, and after his call to the bar became a staff attorney in Dauphin. Practicing primarily in criminal and youth law, Peter has appeared in all levels of court in Manitoba, and in 2009 appointed as the acting area director of the Parkland region of Legal Aid. And in 2011, he moved back to Winnipeg as the senior area director. In 2021, he was appointed the executive director of Legal Aid. He's a life council member of the Manitoba Bar Association and was appointed King's Counsel in 2019. Kristal Bayes-McDonald has served as the director and legal counsel for the Manitoba Law Reform Commission since 2019. Prior to that, she served as legal counsel to the commission and practiced in the areas of family law and civil litigation. She obtained her JD from Queen's University and is an alumnus of Brandon University, where she serves on the Board of Governors. We also have Erin Wilcott. Erin Wilcott is an alumnus of both the University of Winnipeg and Dalhousie and was called to the Bar of Manitoba in 2003. After several years in private practice with a large firm wherein she filled a variety of non-practicing and management roles, she began her role as executive director of the Manitoba Law Foundation in 2019. And finally with us today, we have Byron Williams. Byron is a graduate of Robson Hall and was called to the bar in 1993. He's practiced at the Public Interest Law Center since that time and became its director in 2004. In 2013, Byron was the recipient of the Law Society of Manitoba's Richard J. Scott Award, which was presented to individuals who advance the rule of law through advocacy, teaching, litigation, research, and writing. In 2015, he received the Canadian Bar Association's Legal Aid Liaison Committee's Legal Aid Leader Award. And in 2017, he received an honorary doctorate in law from the University of Winnipeg. And with that, we will start our discussion. The way it's going to work this afternoon is I'm going to ask some questions to the panelists and they'll provide their responses. And then after we've had sort of a more formal Q&A, we will turn to you and your questions towards the end of our discussion. So maybe I'll just start with asking our panelists if they could just take a moment to highlight the role and function of their organization and then their role within it. Darcia, do you want to go first?
Sure, I can do that. Many of you know who I am, and you know what the Law Society is about, but I'm not going to assume that all of you do. So I'd like to just begin by saying that the Law Society of Manitoba is the regulator of those who practice law in the province. And in everything we do, we are required to uphold the public interest in the delivery of legal services with competence and integrity and independence. But how do we do that? So we establish standards for the education of our members, professional responsibility requirements, and competencies that are expected of persons practicing or seeking to practice law in the province. For example, we set standards for articling students who are expected to demonstrate certain core competencies upon being called to the bar and becoming practicing lawyers. We also have a code of professional conduct that contains ethical obligations for lawyers when dealing with clients, other lawyers, the Law Society itself, and the courts. These obligations include, for example, the duty to act with integrity, of course, the first and primary rule, to provide the appropriate quality of service, to meet certain standards of competence, to maintain confidentiality, avoid conflicts of interest, to charge fees that are reasonable, to treat other lawyers with courtesy and respect, and to safeguard client property. And of course, to also encourage respect for the administration of justice. We are responsible for reviewing and investigating complaints about lawyers and for prosecuting lawyers who are charged with professional misconduct, conduct unbecoming of a lawyer, or incompetence. We require lawyers to have mandatory professional liability insurance so that if a mistake is made, members of the public again are protected. We maintain as well a reimbursement claims fund so that on the rare occasion when a lawyer misappropriates trust funds belonging to clients, that there is a pot of money available to reimburse the client so that, again, they are not put at risk. We have auditors on staff who review law firms' trust accounting records to ensure that firms are complying with accounting rules, know your client rules to help prevent money laundering, and rules relating to the handling of client property generally. We also provide professional development, such as the program today, and every lawyer is expected to complete at least 12 hours of CPD training each year. In terms of my role within the Law Society, I'm General Counsel and Director of Policy and Ethics. Previously, I was in charge of the Complaints Investigation Unit, and then I prosecuted for a number of years, prosecuted lawyers who were charged. And then in the last several years, 7 or 8 now, I primarily give ethical advice to our members who can call and ask for guidance on any rule in the code, any kind of an ethical issue, and also work as counsel to a number of different Law Society committees, such as regulating legal entities, what kind of policy decisions need to be made if we want to change the way in which legal services are delivered, the Practice and Ethics Committee, and of course the Access to Justice committees. So that's what I do. I'm ready to pass it on to the next speaker.
Peter?
Good afternoon, everyone. Legal Aid Manitoba is a somewhat unique creature. We are government, but not government. We are civil servants, but we are independent of the government, and we are managed by a management council akin to a board of directors. Simply put, Legal Aid Manitoba is there to provide legal representation services, advice to the minister, and advice in general on matters that are deal with people appearing generally before the courts on a number of different areas. Most people assume legal aid is criminal. Very true. But we also cover family law, child protection law, some immigration, some poverty law, and also some public interest law, which I think you're going to hear a little bit about from Byron. We are made up of a combination of both staff and private bar lawyers. We offer services throughout the province. We have 5 offices across the provinces. as well as operating out of just about every circuit that exists within the province. I'm the executive director, which means that ultimately I'm the chief executive officer of Legal Aid, and I represent Legal Aid both on the provincial and on the national stage. I'm involved not only with local committees and groups such as this, but I am also involved with the Association of Legal Aid Plans of Canada. I'm the one of the representatives to the executive, and I am also the Association of Legal Aid Plans representative to the Access to Justice National Committee. That's pretty much me in a nutshell.
Thanks, Peter. Byron?
Yes, thanks for having us. My name is Byron Williams. I'm the director of the Public Interest Law Center, and we're part of Legal Aid Manitoba. We have a fairly unique role both within legal aid and across Canada. And we represent low-income individuals as well as groups. And what we try to do is issues that are of systemic law reform, things that will set a legal precedent and affect a larger population, or just affect a large number of Manitobans or Canadians. And we really focus on being evidence-based, nonpartisan. We end up fighting mostly with governments. That might be the federal government, the government of Manitoba, or a municipal government, or with large corporate organizations, a forestry company on behalf of our clients, or Manitoba Hydro, organizations like that. And I'll turn it back to you, Natasha. Thank you.
Thanks very much. Kristal?
Hi, everyone. I am the Director and Legal Counsel for the Manitoba Law Reform Commission, and we are the independent law reform agency in the province. And we were established with the enactment of the Law Reform Commission Act in 1970 and started operating the following year. So we have been in existence for 52 years. Members of the commission are each appointed by order in council, and there's currently 7 commissioners in total. There are 3 practicing lawyers currently. Excuse me. I'm hoping my voice will carry through this next 2 hours. Wish me luck. 3 practicing lawyers, 2 judges, and 2 members of the faculty of law, one of which is a non-lawyer, and that is set out in our statute who is to sit on the commission. The mandate of the commission is also set out in our enabling legislation, and it is, and I'm gonna quote from the legislation, to inquire into and consider any matter relating to law in Manitoba with the view of making recommendations for the improvement, modernization, and reform of law in Manitoba. And then the act goes on to provide some examples of, how could we do that? And that is, or how would this work take shape? And this includes the removal of provisions that are outdated or inconsistent, the maintenance and improvement of the administration of justice, the review of judicial and quasi-judicial procedures under the Act, and the development of new approaches and new concepts in law. So what does this mean in practice? Well, practically, what this means is that the commission selects specific areas of the law to study. Typically, those areas are proposed by lawyers in the community, the public at large, or perhaps the public service. We conduct research, comparative research, as well as historical research as to what the intended purpose of a specific act or provision was. We then consult with outside stakeholders and ultimately prepare a final report containing recommendations for reform that is then provided to the Minister of Justice and Attorney General, hopefully for implementation. We're a very small agency. Currently, I am the only employee, so we're limited in the number of projects that we can take on at one time. And then once we complete a project, we will take on additional work. And finally, I just wanted to say that the commission is receives funding from the Manitoba Law Foundation, which Erin will be speaking about, as well as the Department of Justice. And I'll give it back to you, Natasha.
Thanks, Kristal. Last but not least, Erin.
Hi, everyone. My name's Erin Wilcott. I'm the Executive Director of the Manitoba Law Foundation. We are a small not-for-profit organization with a mandate to encourage and promote legal education, legal research, legal aid services, law reform, and law libraries. And we do that by providing grants to those ends. We were established in 1986 by amendment to the Law Society Act, which is now the Legal Profession Act. We're governed by a board of 10 members. Appointments are made by the Minister of Justice, the Law Society of Manitoba, the Manitoba Bar Association, and the Dean of the Faculty of Law, or someone that the Dean appoints, is a de facto member of our board. Our revenues come primarily from interest earned on lawyers' pooled trust accounts. Lawyers in the province are practicing in the province are required to direct their financial institutions to direct interest on those pooled trust accounts to the foundation. We are not unique. We're a unique type of not-for-profit, but we're not unique in Canada. Each of the provinces and territories have their own law foundation, each created by their respective jurisdictions' legislation. I just wanted to mention, because it kind of sets the stage for some of the discussion later, that we recently completed a 5-year strategic plan, which identifies strategic objectives of increasing access to justice in northern and remote Manitoba, as well as increasing access to justice in rural Manitoba and enhancing the profile of the foundation. In terms of my role at the foundation, we are similar to the Law Reform Commission, very small. It's myself and another 0.5 person who plays an accounting services manager role. So generally my role is to provide recommendations and advice to the board on our grant applications, but to fill in all the other little gaps that come with running a not-for-profit. So pleased to be here. Thank you, and welcome to everyone who's attending.
Thanks, Erin. So I guess with that, we'll turn to our first question. So each of your organizations are, as you've all sort of touched upon, are legislative creatures that working to improve access to justice. However, the respective governing statutes don't necessarily make specific reference to access to justice. How do you reconcile your access to justice work with your legislated mandate? Maybe I'll start with you, Darcia.
Okay, well, in my introduction to what the Law Society, who we are, what we do, I talked about our mandate. And you're absolutely correct. There isn't anything in the Legal Profession Act, which is our governing statute, that specifically says that the Law Society has a direct obligation or a role to play in terms of increasing or improving access to justice. However, with that in mind, as I said, our mandate is to do everything that we do as a regulator relating to the provision of legal services in the public interest. So the benches, in their wisdom years ago, decided to create what they call ends or goals overall for the organization. And in fact, one of the end goals that they created was that legal services are reasonably available to the public. And again, that's because we have to keep the public interest in mind. We aren't the Bar Association, and I'm a proud member of the Bar Association, but we aren't an organization that's there to kind of promote specifically and advocate for members' interests. We are there to protect the public. And we certainly have been well acquainted with studies that have been done over the years and all the various reports that outline how members of the public have a lot of unmet legal needs. And legal aid does an admirable job of providing legal services in certain areas of the law for those members of the public who have no ability to hire a lawyer and need those legal services. But we know that there are many members of the public who simply cannot afford a lawyer. And so they tend to turn to the internet and go to friends. They do their own research, talk to buddies, that kind of thing, who might happen to be lawyers, and get some guidance that way. And we know that that's not acceptable. Members of the public should be able to access legal services on a reasonable basis. And ever since the Roadmap for Change report came out, the Law Society has been actively engaged on the access to justice front, and we have tried to act both as a leader and as a collaborator on addressing access issues. There was a recommendation in the Roadmap report that each jurisdiction across the country create an access to justice, like a steering committee, a provincial or a territorial committee for the entire jurisdiction. And Manitoba created one at the very end of 2014. And the Law Society determined that it would host that committee within our offices, and I acted as a resource to that committee. It wasn't simply populated with members of our board. We had other people on that committee, of course, but terms of reference were developed, and we coordinated regular meetings of that steering committee and also of a larger stakeholders committee that would meet at least twice a year to exchange ideas and try to exchange information both about what worked and what hasn't worked, because that can be just as valuable. With our strategic plan for 2017 to 2020, our board determined that as one of the Society's 4 strategic objectives, we should demonstrate leadership in the advancement, promotion, and facilitation of increased access to justice for all Manitobans. And desired outcomes were articulated as follows. Manitobans will have access to the required complement of appropriately trained lawyers and legal service providers to meet their legal needs. The Law Society will advance, promote, and facilitate the delivery of quality, innovative, accessible, and affordable legal services, including pro bono services. And the Law Society plays an active role regarding access to justice issues and ways to increase access. And we then identified specific strategies that would help us achieve that objective. For example, we decided to explore giving up our monopoly on the provision of legal services. And one activity that we landed on to advance that strategy was giving consideration to the removal of regulatory barriers that prevent legal services from being reasonably available to the public. We also decided to increase collaboration with the courts and other justice system stakeholders to advance, promote, and increase access. And finally, we also determined to promote the unbundling of legal services, encouraging lawyers and educating them about taking on limited scope, what we refer to as limited scope retainers, because sometimes members of the public don't really require the full meal deal, if I can put it that way. It's more of an a la carte. Maybe they need help getting the statement of claim filed. Maybe they've managed to do that on their own and they need help with an examination for discovery, for example. So that kind of thing. For our next strategic plan that followed that one, the Society determined once again to make advancing, promoting, and facilitating increased access to justice for all Manitobans a strategic objective. The new desired outcomes were stated to be as follows. Manitobans in northern and rural communities have increased access to legal services. Manitobans can choose to access the delivery of legal services from a wider range of legal services providers, so not just from lawyers. So much like the medical profession has moved over the years, it's taken some time to a model where you can now, for example, get your flu shot or your COVID vaccine shot from your pharmacist. Many people have health nurse practitioners instead of doctors. Not necessarily by choice, but at least they have somebody they can go to who's trained to provide a certain level of services competently and without risk to the public. Some of our strategies for this current strategic plan are to engage with Manitobans in rural and northern communities, to engage with members of Indigenous communities and others about unmet legal needs and opportunities to address them, further explore ways to remove regulatory barriers, and to promote and facilitate further collaboration and cooperation among justice system stakeholders.
Thanks, Darcia. Peter? Oh, you're muted, Peter.
And we all knew I was going to be the first one to do that. Thank you very much. So Legal Aid Manitoba has always been, to some degree, in the business of access to justice. We have always been in the business of providing legal services to those who could not afford a lawyer. And we do that primarily through the provision of legal counsel and duty counsel services across the province. As I indicated, primarily our concentration has been on our core services of criminal, family, child protection, and immigration refugee law. Over time, this has increased, and we'll be discussing some of the changes later on, and I am mindful of the time. But one of the interesting ways that Legal Aid Manitoba has been adapting our access to justice and reaching out to other areas and to increasing access is through our Public Interest Law Center. And on that note, I'm going to punt this to Byron to answer how we use PILC.
Thank you. When we think of the legal problems that people face, they may face them as individuals. That might be a civil matter or a family or criminal matter, but it also could be systemic barriers in society that affect people who are, especially those who are a member of vulnerable groups. It could be the barriers in how we design social programs for persons with disabilities. It could be in the treatment of the calamity caused by the colonial child welfare system on First Nation and Métis kids in care. And so what the Public Interest Law Center tries to do is work with low-income individuals or vulnerable groups on addressing those larger systemic barriers. And we do that through going to court or to important administrative tribunals. We do that through supporting our clients in broader law reform campaigns. That might be media campaigns and trying to persuade politicians to do the right thing. And we also work closely with their clients, not just to give them legal representation, but to assist them in better representing themselves in learning some of the tricks of the trades for advocacy that we have learned along the way. And with that, I'll turn it back to you, Natasha. Thank you.
Thanks, Byron. Kristal?
I'll be quick here. I think it's interesting. Peter was talking about the facilitation of the access to justice issue. Byron was talking more about the barriers, trying to remove barriers, talking specifically about court action. And I see the Law Reform Commission slotting in similar to PILC on the barrier side. But what we're looking at is removing barriers from the statutes and the legislation that governs Manitobans. So even though access to justice isn't set out as in our legislated mandate, I think that's likely just because it's been a very long time since our statute has been amended. I think if it was written today, it would be. And when we're looking at removing inconsistent provisions from acts, when we're looking at new and improved ways of facilitating justice and the administration of justice, we are simplifying, we are making things more comprehensible to not just lawyers and represented litigants, but self-represented litigants as well. I think that is any of this law reform work is improving access to justice.
Thanks for that, Kristal. Erin?
Hi, thanks. I'll be quick because I know we're short on time here, but there is no specific reference to access to justice in our legislation, but I did talk about our mandate of encouraging and promoting legal education, legal research, legal aid services, law reform, and law libraries, SARA grant making. And I would say access to justice is inherent to all of those things. You cannot have it if there is no public legal information and education offered. You cannot have access to justice if there aren't legal aid services or law reform, as Kristal's spoken about. Legal research is necessary to identifying and understanding access to justice issues. So it is inherent to the work that we do. And our board has recognized that in setting its vision and mission for the foundation. The vision is advancing justice through access, knowledge, and understanding. And the mission quickly references, I'm just going to point out the part that references facilitating community understanding of the justice system instead of reading the entire mission out for you. But yes.
Thanks for that, everyone. As I mentioned sort of in the introduction, it's the 10-year anniversary of the Roadmap for Change report. And in the executive summary of that document, it states that there's a serious access to justice problem in Canada. Do you think this statement reflects the state of access to justice 10 years later in 2023? Peter or Byron, either one of you from Legal Aid want to take that?
If I can just jump in right at the beginning and then I'll pass it over to Byron. I think the statement is sadly still very, very true. I think that there's a long way to go on access to justice. And I think that that is not because we haven't done anything. The simple reality is that guidelines for getting legal aid in Manitoba have changed drastically. We offer more services now than we have in the past. We offer higher guidelines. Individuals who are working poor can now access legal aid either on a for free or on a reduced payment system. And those are all great moves forward. Legal Aid was one of the first organizations to push the idea of collaborative law in dealing with family law issues. And that has now become a standard practice in dealing with a family law issue. You have to try and come up with some sort of negotiated settlement before you even have access to the courts. But the reality is that all of these issues are now far more complex. We are recognizing that our foundational beliefs are in fairness wrong, as we discover with changes and growing awareness of the effects of colonization, the effects of racism within our systems. All of these things are sending challenges to the law and are demonstrating that access to justice, fundamental access to justice, continues to be an ongoing societal issue. Byron?
There is still a serious access to justice problem in Manitoba and in Canada. In some ways, it's got worse. I'll flag a couple of negatives. Think of our human rights system in Manitoba, where it is just burdened and very slow moving. Think of the absence of important environmental hearings in Manitoba over the last few years, or think of efforts by government to take away the rights of kids in care to actually sue to realize or to challenge government decisions that clawed back their benefits. So we've seen some real attacks on access to justice, including through underfunding by government. On the positive side, and in our practice, changes to the Queen's Bench rules and practices have really facilitated our ability to get constitutional cases on systemic law reform matters through to the courts quicker. And we've turned around a couple of really important constitutional cases within a year, which to me is pretty timely access to justice. Picking up on one of Peter's themes, I just want to flag that we're coming to slowly realize that we're in the midst of a fundamental change in terms of access to justice. And we're just starting to grapple with how our Western colonial legal traditions relate to First Nation and other Indigenous legal traditions. Issues like the environment, child welfare, issues like community health and safety. And we're just starting to acknowledge that now. We're not quite sure as Canadians how to address those issues, but I see that as a fundamental challenge to access to justice as we work our way through that towards reconciliation going forward. Thank you.
Thanks for that, Byron and Peter. Darcia, do you have anything to add?
I think I would just echo both the positive and the negative, perhaps in different ways, but there continue to be reports that have been done, studies like the Stats Canada 2021 study, Canadian Legal Problems Survey, that still shows that there's a real need for all sorts of legal services that aren't being met. But there are some positives. In light of the, for example, call to action 27 of the Truth and Reconciliation Commission, the Law Society has specifically developed and just launched on October the 1st, a mandatory cultural competency training program for lawyers called The Path that has to be taken. And obviously requiring our members to be more attuned to the very issues that Byron was just discussing can only assist in improving access to justice, not just access to legal services, but access to justice, which is, I think, a broader term as we've come to understand it. So, and I think that's a positive. It's good that we're finally recognizing some of these historic wrongs and taking steps to do something about it. And, the Manitoba government also rolled out its rather bold family law modernization project, which I think really tries to follow what was the essence of the Roadmap for Change report, which was courts if necessary, but not necessarily courts. And they've rolled out in phases that plan, which has resulted in the creation of the Family Resolution Service, which is launched in phases to deliver on the website, it says a seamless continuum of public, private, and community-based services to Manitobans and support existing and future changes to family law. So I think that's also very positive. Sure, there's always room for improvements. And as these things are piloted and rolled out, I'm sure stakeholders can comment as they wish on the efficacy of these new programs.
Thanks for those comments. And, it's clear that we have a significant ways to go. The Roadmap for Change lists guiding principles for change, specifically put the public first, collaborate and coordinate, prevent and educate, simplify, make coherent, proportional, and sustainable, take action, and focus on outcomes. Can you maybe share how your organization has successfully applied these guiding principles in its access to justice work? Or are there any guiding principles that your organization needs to improve on? Maybe Kristal, did you want to take that one first?
Sure. So there is one of those guiding principles that sticks out to me as being directly applicable to the work of the Commission and really what we're striving to do with our work, and that's the simplification of the law, making it coherent, proportional, and sustainable. All four of those words are directly related to the work that we're doing. So I spoke in my previous answer just very quickly about the work that we do, the fact that the statute law in Manitoba is static, right? It changes when it's been changed. We are not alone. We're not the only jurisdiction that where Manitobans are still governed by pieces of legislation that have come to us from England, pieces of legislation that were enacted a long time ago and have received very little concern in the recent past. And more of an issue in Manitoba is we have pieces of legislation that have been amended over the years in a real piecemeal fashion. And so some of the acts that we're dealing with don't make a lot of sense. They're not very cohesive, and there's duplication in acts and inconsistencies. So the work of the Commission, we are looking to simplify the statutes. We're looking to codify procedures where that would enhance access to justice in certain situations. And we're looking at perhaps amalgamating pieces of legislation that are common into one act, always with the goal of making it easier for not just lawyers, although lawyers appreciate this type of work too, we're told, but also self-represented litigants to in fact know what the laws are that govern them and the processes that they need to undertake with respect to them. So another example would be our mandate indicates that we are to undertake reviews of judicial or quasi-judicial procedures under the Act. So when the Commission is examining legislation, it's identifying areas where the law is no longer appropriate and where efficiencies could be found. And this obviously improves access to justice where a client or a party doesn't have to spend as much time in the system and doesn't need to exert the same amount of resources to receive that legal remedy that they're looking for. And just lastly, another way that law reform work improves access to justice by simplifying the law and making it more coherent is considering how Manitoba's laws could be more consistent with the laws of other jurisdictions, particularly in Canada. When laws are uniform or where there is a level of uniformity between jurisdictions, there's fewer challenges for those trying to navigate a legal problem that doesn't fit nicely within one geographic jurisdiction. So that's something else that the commissioners look at when they're analyzing a particular legal issue. And then with respect to the sustainability of Manitoba's statute laws, this is also part of the commission's analysis when they're looking at a specific area of the law. How do we ensure that when the commission is recommending changes, that new reformed legislation is not outdated in 5 years? And this may mean recommending that, for example, quantums are removed from the acts themselves and are either put into regulations, or maybe they're tied to the consumer price index or something to that effect. So this is part of the process when the commission is studying and reviewing any area of the law, is trying to identify ways that the simplification, the comprehensibility, the uniformity of a law, and also the staying power of a law. How is that going to impact the ability of Manitobans to access justice?
Thanks for touching on a lot of those principles, Kristal. Erin, what about the foundation?
I'm going to touch on 2 of the principles. I think the foundation has made significant headway with the principle of collaborate and coordinate. We've been working to strengthen our relationships with the Law Society, Legal Aid Manitoba, the Bar Association, and the Faculty of Law, and are beginning to collaborate on some significant issues. We've also done this, encourage collaboration and coordination through our grant making. A very good example would be the grant to the Faculty of Law for your position, Natasha, as Director of Access to Justice and Community Engagement. There are many organizations in Manitoba that are doing a lot of really good work to advance access to justice, but it's been done in silos, and that's, it's time-consuming work, it's difficult work, and there often isn't time to set time to meet and collaborate and coordinate, and your role is going to help with that. And then I would also point out that the foundation likes to encourage collaboration and connection amongst its grant recipients, and will often connect new applicants to existing grant recipients so that they can help them out, or they have shared goals or similar work. So I think we're making some headway there. In terms of one that we really need to work on, I would say that would be put the public first. The foundation has been doing that with its grant making, in terms of making sure there's public legal information and education and legal aid services. But this has historically been a very Winnipeg centric. The applications we receive are coming from organizations in Winnipeg, and are mostly benefiting those that live in Winnipeg. And 40% or so of our province does not live in Winnipeg. So as I mentioned earlier, our strategic plan has recognized this need to increase access to justice outside of the borders of Winnipeg into rural Manitoba, northern and remote Manitoba.
Thanks, Erin. Byron, what about PILG?
I'm going to just focus on one, collaborate and coordinate, and that may sound weird coming from us because we're usually in a very adversarial position with government, but we were approached a couple of years ago by the Northern Chiefs, the Manitoba, Kiwatanawe, Okanagan, and they had a long-standing problem, 25 years, where both the RCMP and public prosecutions had failed to prosecute and enforce their health and safety laws. And that came to a head in the COVID pandemic, and the issue of COVID was being further inflamed by an additional plague of booze and drug running in their First Nations. And what we've been working on in a surprisingly collegial and coordinated way over the last 2.5 years is working with 4 federal departments, as well as our Department of Justice, obviously led by the Northern Chiefs, but with legal aid support on a whole of government response to try and get at these systemic barriers to the enforcement and adjudication of health and safety laws, and also leading to broader community results. Some examples of that collaboration, 2 recent changes to provincial legislation were there was collaborative writing of those provincial amendments by the Northern Chiefs with final say by Department of Justice. There's 2 pieces of federal legislation that are proceeding, and we've been collaboratively writing bylaws for First Nations that are reflective of their traditions and their priorities, but working them through with federal justice to make sure that they're charter compliant and consistent with best practice. And it's a shockingly collegial and collaborative result. And it's essential because what had happened because of the 25 years of federal inaction was a rule of law crisis on reserves where there was no confidence in the administration of justice. And we have a steep hill still to restore confidence, but it's we're starting to get increasing buy-in from First Nations and from the RCMP and from prosecutions, and I have new friends at the federal and provincial government, at least on this one specific issue. Thank you.
Thanks so much, Byron. Darcia, what about the Law Society?
I don't know how much time we have left with this question, Natasha.
Go for it.
And I think I went too long in another one, but I'll just raise one of our initiatives that was for us putting the public first and trying to remove some barriers, regulatory barriers. We amended our rules in the course of the last couple of years to allow for the provision of legal services through entities other than law firms. And it was determined that we, as the regulator, should really relax our regulatory framework, because traditionally legal services, unless they're delivered through legal aid, are delivered through law firms. And we decided that in terms of putting the public first, we should be meeting people where they're at. We would read that often in reports that when people are accessing a civil society organization, which is what we ended up calling these organizations, perhaps getting a food hamper, perhaps a woman going to a woman's shelter who's fleeing from a domestic abuse situation. They're already accessing certain critical services, and of course very often they already have legal issues, or they may have tangent legal issues. Sometimes they're aware of them, sometimes not. Sometimes they actually have overlapping issues and more than one legal issue, and yet to get that person in front of a lawyer is often just impossible. It's not workable, whether it's for fees, childcare. They can't get to an office on certain hours, and so we have permitted civil society organizations to apply to us, and they're defined as a charity or not-for-profit, to permit the provision of legal services by a lawyer, but through that organization. So at the same time that somebody is picking up a food hamper, they could be getting legal advice and trying to deal with individuals in a more holistic fashion. And the key to that is that the services have to be delivered on a pro bono basis. The CSO could ask for lawyers to volunteer, maybe one day every 2 weeks, to provide a half a day of services, or the CSO, perhaps with a grant from somebody like the Manitoba Law Foundation, could hire a lawyer to be on staff. But again, the key is that the services to those members of the public accessing those legal services have to be for free. So the lawyer could be paid as an employee. The lawyer could also receive an honorarium as an independent contractor and come in again, just maybe once every week or so. So we are excited about that. When those rules were coming into effect, it was right around the time when COVID happened. And unfortunately, that slowed down the uptake for organizations who were also hit financially as a result of getting less donations coming in during COVID and whatnot. But that's one example of where we were trying to put the public first and meeting people where they're at.
Thanks for speaking about that initiative. A couple of you have touched upon your goals and initiative, or your goals with respect to rural Manitoba. And we know that geography persists as a major barrier to access to justice. Maybe can you speak to the challenges surrounding access as legal services in rural and remote communities and the future of access to justice outside city centers? Maybe Erin, I'll start with you.
Unfortunately, you're starting with me because I
Oh, I can't hear you all of a sudden, Erin. Okay, well, Erin gets that sorted out. Maybe we'll just go to another person while you deal with your audio, Erin. Kristal, did you want to go next?
Sure, but Erin, you don't have very long because this is a very important topic, but it's one that the Commission is in the very early stages of considering. So I won't be able to fill too much time. But what I will say is that, yeah, this issue of unique barriers to access to justice, specific to how the legislation and regulations of Manitoba, as well as our administrative processes in justice and in the court system, how they affect Manitobans living out of major centers. This is something that the Commission has currently turned its mind to. We have in 2019, we did undertake our first project specific to Manitobans living outside of major centers, and that was the consideration of specific provisions of the Manitoba Evidence Act and how legislative requirements under that act for the witnessing of declarations and the signing of affidavit evidence, etc., being the witnessing of that needing to be done in person, what the impact of that was on individuals living outside of major centers. And the timing of that project was interesting because we were about a year into that project when the pandemic occurred, and the Law Society of Manitoba and the Department of Justice stepped up very quickly, identified this as a problem, and did make some changes on a temporary basis. We did continue with our work. We consulted with individuals living out in remote northern Canada, and did ultimately recommend that in specific circumstances that witnessing requirement be able to be done remotely. That was the first project. We are now considering a second phase of that project and what other pieces of legislation ought to be reformed in order to remove barriers that are specific to Manitobans living outside of Manitoba. And just very quickly, I would just plug that if any of you have an idea as to a specific piece of legislation that does have that impact, I would be very much wanting to hear from you on that.
Thanks, Kristal. That wasn't nothing. That was a fulsome answer. Don't knock your impact on the work you're doing for rural and remote community. Erin, how's your audio?
don't know. How's my audio?
It's good.
Okay,
it's
good. As I was saying, I don't have firsthand experience of the barriers. I hear about them from others, like from legal aid, like Peter and Byron, and the Law Society. But I know they're there. I know there's a lot of them. I know we have an immense amount of work to do to remove those barriers. But I think the key will be working with the communities that are affected by those barriers in finding ways to address them and to take their lead in finding solutions and implementing those solutions. Yeah, I think that's really about all I have to say on that. And I'm going to let Peter jump in because I know he has lots to say about barriers.
Go for it, Peter.
Thank you very much. I do have lots to say. There are huge barriers, both even in just providing basic services or in accessing even remote services. Many communities, especially in northern Manitoba, don't even have access to basic things that we take for granted: the internet, telephones. If somebody has a phone, which would be a wired phone because there's no cellular service, then that's a rarity. If somebody has a cell phone, there's minute problems. We don't have enough time. There's no such thing as Wi-Fi. It's an incredible factor. And one of the major factors that we're really seeing now, and it's not just in Manitoba, it is across the country as I meet with my counterparts in other provinces. And that is the lack of lawyers who are willing to tackle work outside of the perimeter. And I speak as somebody who I originally am from Southern Ontario. I moved to Winnipeg, went to law school, and went and lived in Dauphin, which was a fantastic community, and raised my kids in Dauphin. I came back because this is where my job came to. But it wasn't a situation of wanting to leave. Lamb has offices in Dauphin, Brandon, the Pas, Thompson, as well as Winnipeg. But we rely heavily on private bar counsel in all of those communities. More importantly, we rely on private bar counsel who are also in even smaller communities: Flin Flon, Roblin, Swan River. And it's important for a number of reasons. Not only do they provide legal services, which legal aid can't: corporate information, farm information, wills, estates. But, and they're doing this quite often literally on the sidewalk. They're available there for someone to ask a question of as they build those relationships. But there's a significant Chamber of Commerce issue. And I think that this is something we often don't think about. Local law offices, whether it's staff from government or whether it's private bar counsel, also are a major part of every community. These people, both staff and lawyers, tend to sit on boards. They tend to volunteer heavily. Not everyone joins a fire department, but many do. They become the scout leaders. They teach judo. They do all of these types of activities, and they build the community. More importantly, they build awareness in the community. So these are the people who tend to go to the schools to talk about access to justice, what lawyers do. These are the people who are showing up on National Duty Council Day, things like that. They're the people who may be in the local newspaper explaining why something was done. There are lots of things that we can do to provide remote services, but it doesn't address the impact that is being felt in these smaller communities by the loss of the lawyers who provide both legal and non-legal advice and leadership in those communities. And I think those are something that really we need to address. It's access to justice is many things. And Darcia said it quite clearly. It's not just access to legal services. Justice is far more. And the function that lawyers provide for many smaller communities is absolutely vital. And it's something that as a profession, we are really losing. And it's very unfortunate. And it's going to have a very big impact on our society as a whole, and ultimately upon how justice is seen by our society. My rant.
No, a needed rant. Darcia, do you have anything to add?
I was going to say some of the things that Peter's already said, so I'll shorten my remarks on this part. The Law Society has been talking for years about the graying of our population of lawyers. So, and a lot of our senior lawyers who were baby boomers who are now retiring. So even the pool of existing lawyers, even within Winnipeg, so not even talking about northern and rural areas, is shrinking. But of course, the issues are just exacerbated in the north. And we tried with an initiative called our Forgivable Loans Program years ago, and then we tinkered with it, where we set up a program whereby articling or law school students could get a loan from the Law Society that would be forgiven if they agreed to practice for a defined period of time in a remote northern community or an otherwise underserviced community. And for a variety of reasons, there wasn't a lot of uptake on it. We think that some of the parameters of the program didn't work. So then we, as I said, tinkered with them. We're still looking at it, but we're open to new ways of trying to explore how to get needed legal services into those rural and remote communities. And in that regard, Natasha, when she became the Access Justice Coordinator, first through the Law Society, thank you, Manitoba Law Foundation, for another wonderful 2-year pilot project grant. She started working groups, revitalized the work of the steering committee. And one of those working groups is talking about trying to determine if trusted community intermediaries could play a role, a much larger role in these communities. They're already filling in and doing all sorts of things that some people might already think that they're crossing the line and providing a limited legal service, but they're already trusted members of the community. If they are able to provide certain services competently, why wouldn't we figure out a way to help them do just that? And in fact, one of our initiatives overall, not just for the North, is our sandbox initiative, our regulatory sandbox, where we are asking people who aren't lawyers in particular. Lawyers can also apply, but we're asking in particular people who aren't lawyers to make an application to us if they feel that they are competent to provide a certain type of legal service. It has to address an unmet legal need. So demonstrate to us why you're competent to provide this service. Why? Because again, we have to protect the public. We're not talking about people who don't have the LLB behind their names and they're not called to the bar. But we believe that there is certainly room for individuals who aren't lawyers, who can be very capable in providing needed legal services. So we've launched our sandbox. Again, uptake has been fairly slow. Some of the other larger jurisdictions have a handful of individuals as well, and they've been up and running much longer. So we remain hopeful. There's no end date to this pilot project right now. There isn't even a requirement that it be tech related. Ontario's sandbox has to be a tech initiative. So that's just another way that we're looking at trying to see if we can be creative. And we hope that the policy work that we need to do going forward to start figuring out what a limited practitioner might be able to do, how we could give a license to somebody who's not a lawyer on a limited basis and call them a limited practitioner. We need some data to help us with that. And so we're hoping that some of the successes that we'll hear about through the sandbox will really help inform our policy decisions going forward. And that can only be a good thing for the North.
Thanks, Darcia. I actually just put in the chat for everyone the link to your sandbox if they wanted to learn or read more about it. Maybe, Darcia, I'll just ask you the next question, because I know that you've been sort of thinking in this space in terms of the role AI might have in access to justice. What do you think the impact will be with respect to generative AI? And should lawyers be using it when providing legal services to meet an A to J need?
Okay, well, in a very thumbnail sketch, the Federation of Law Societies just had their national conference about a week and a half ago, 2 weeks ago, and the entire conference was on AI. And we learned a lot. I think that all of the regulators have to educate themselves much more. Some of us have done a deep dive into what it means, others not so much, especially some of the smaller law societies where they are like, Erin, for example, one person trying to do everything. So we've determined that we need to do more to educate ourselves. But we've already, for example, like I wrote an article months ago that I feel already needs to be updated about after generative AI, the chat GPT that everybody, of course, made famous by the lawyer in New York who made a mistake and didn't, well, more than a mistake, didn't check their documents. They relied on chat GPT and got caught with citations that were non-existent, fake cases. They call that hallucinations. So I wrote an article about how certain professional code of conduct obligations come into play. We have an obligation for lawyers to be technologically competent. We made that rule amendment years ago. Most law societies across the country have already adopted that rule. And even if they haven't, again, just the basic requirement to be competent, lawyers have to keep up not only with substantive case law and knowledge of legislation that's changing, but the way to practice. I mean, there was a case that I'm aware of already 13 years ago, I believe, where a judge lowered a lawyer's fees because they said, well, why weren't you doing computerized legal research? And at some point, it can become the new norm. So if a lawyer is able to provide competent, accurate, with all the safeguards, respecting confidentiality, making sure that you're using tools that aren't such that they can take your confidential client information and use it again to help train the tool further. There are tools that are specifically designed for lawyers, AI tools. So if you learn to use those properly, why wouldn't you be able to provide more efficient services to your clients? Instead of a junior, for example, doing research for 7 hours on a memo, an AI assistant with human oversight, okay, could maybe do that in half an hour. And that's going to raise interesting questions, I think, in the future about the reasonableness of legal fees. If you're not able to charge per hour anymore, and yet the lawyers had to go through all that training to bring that essential human judgment to the equation, and they should be fairly compensated for it. But I think the market will start changing that. In terms of members of the public using AI themselves, there's already a lot of direct-to-consumer applications out there that provide a whole host of legal information, some of them quite badly. We don't always know who's providing that information. Maybe it's somebody in another country who knows nothing about Manitoba law. So, it's kind of like buyer beware. Use that at your peril. But I think the Law Society, as the regulator, could also do some work on educating the public about the risks and potential benefits of using some of these tools. So it's very topical. The Pip-Lato lectures in a couple of weeks are also going to be all on AI. So encourage you to follow up if you're interested as Law Society members and start learning about these things, because they're already here.
Yeah, and they change daily. So
Exactly.
I was going to make the plug for the Pip-Latos, but you just did. So if you're want to hear more about it, then tune into the Pip-Lato lectures. Some of you spoke to the guiding principle of collaborate and coordinate, and are there ways in which your organization could better work together to promote or enhance access to justice for Manitobans? Or what are the ways in which your organizations are already doing so? And I know you've already touched on a couple, but do you want to expand on that, Byron?
I'm happy to, Peter, if you want to lead off, or I'll just go ahead. Okay, thanks. And I don't want to give too much credit to the Law Foundation, but I am going to talk about a number of activities that we've done with the support of Law Foundation funding, primarily from the Manitoba Law Foundation, but also the Ontario Law Foundation. And just elaborate a little bit more as well on Darcia's point about sandboxes and how a number of us have worked together in terms of civil society organizations. In terms of some Law Foundation activities, just one that's ongoing right now. We're working with a really unique group of network of organizations supporting Manitoba seniors, and some of them are low income, supporting low income populations. Some are racialized populations. Some are Indigenous populations, the LGBT community, as well as folks living in rural or northern Manitoba and folks living with disabilities. And the purpose of this endeavor is to identify some of the leading systemic barriers that they're facing, and to identify law reform strategies to address it. You saw one of those most recently in the Manitoba provincial election with that recommendation for a seniors advocate. And a lot of the thinking and coalition building around that came out of this activity. We're working coming up in November with quite a disparate group of environmental service providers and to identify the top few priorities that they can work together on for law reform and change as it relates to the environment. That might relate to critical minerals, it might relate to climate change, but again, that's a Law Foundation activity. Some of the work that's been Law Foundation funded that we're most proud of is our work with the support of the Ontario Law Foundation on working with traditional knowledge holders and academics and First Nation leaders to codify template laws relating to the families. And for the 5 major First Nation language groups in Manitoba. And to me, that's a fantastic project. Speaking to that, how we're trying to grapple with how First Nation legal traditions may relate to colonial legal traditions. One that I think Darcia and perhaps Erin have hinted at is working with the First Nation Family Advocates Office to provide their outstanding in-house legal services a really more holistic legal service than than what legal aid offers for families who are involved with the child welfare system. And that service is it's a great collaborative effort. It's received Law Foundation support, regulatory support from the Law Society, and so much mentoring support from our friends at the Child Protection Unit within Legal Aid, as well as from the Public Interest Law Center. And we're working with those really gifted lawyers as we speak on important inquests, trying to develop and work with them as they develop their law reform skills. And just one general comment as well. The very work that PILP does is inherently collaborative. We work with so many community organizations, and we often do it as coalitions. And so our clients for Barrier Free Manitoba, who've made fantastic differences in Manitoba on the Accessibilities for Manitobans Act, the Disability Support Act, that's a coalition of over 100 groups representing persons with disabilities. I don't know how they keep those groups together. It's a bit of miracle working from my perspective, but that is an example of how we use the supports we receive from legal aid, the supports we receive from the Law Foundation, as well as the volunteer efforts of members of the Manitoba legal community. And we've been honored to support our clients in activities like that. Thank you.
Thanks for highlighting those, Byron. Peter, did you have anything to add from legal aid?
I was going to comment on FNFAO as one of our prime things that we were so proud of working with them. I think one of the big benefits of the CSO, especially in areas where their work overlaps with work that is traditionally legal aid, is that while we cannot pay them fees, what we can do is cover things like disbursements. So in many ways, it is actually doubling up the available service that's available. We're able to provide these services at a reduced rate from the taxpayer's point of view. And we're getting generally a greater opportunity to provide those services. And getting them into groups that otherwise would not necessarily turn to the traditional legal services or would feel very uncomfortable in traditional legal services. So the CSO has really been a fantastic addition. As an organization, one of the things we're also doing is we are constantly tracking the impact of those organizations from a cost point of view, because if they disappear, that is going to fall back again, in some cases, on the public purse. So it's important that it's not just that it's an access to justice, but that it is filling a gap that will be very, very hard to patch if they're not there. So I'm thrilled to be working with FNFAO and the Association Juridique, as well as other groups, but it's really made an impact and a change in how we operate.
Thanks, Peter. And just for those of you who don't know, He's referring to the First Nations Family Advocate Office for the FNFAO. And just to quickly comment on a question in the chat, Darcia, correct me if I'm wrong, but when we speak about civil society organizations, those organizations actually have a called practicing lawyer on their staff to provide their legal services. There's a couple questions in the chat that speak to how are they regulated. They're regulated because the person providing the legal services is in fact a lawyer, correct?
Exactly. The CSOs is to allow the provision of legal services through something other than a law firm. So through these community organizations that are charities or not-for-profits, for example. That was the original plan. We've massaged that somewhat, and I'll talk about that in a moment, but certainly it is still lawyers providing the services. So the lawyers have to ensure that they are mindful of their duties to maintain client confidentiality. If you're providing services on a table at Salvation Army, for example, you can't just have your notes about so that anyone else could see them. So it is the lawyer individually who's being regulated and continues to be regulated by the Law Society, however they're providing those legal services. I should say that the very first CSO that we approved, it was interesting for us and a little bit challenging because it didn't meet the definition that the benchers had just come up with, that it would have to be a registered charity or a not-for-profit organization. Notwithstanding that, in an effort to again to be getting out of the way, putting people first, it was such a good idea. We recognized that, and our benchers decided to allow a presentation to be made to them to explain why they should approve this very first CSO, even though it didn't meet that definition. And in fact, what's happened now is in the last several months, as a result of a committee's recommendation, the benchers have determined that we need to, and we ought to, and we will. It hasn't come back to them yet in finalized rule forms yet, but we are going to be changing the definition of a CSO to allow for other types of organizations like legal clinics, for example, experiential clinics that are popping up all over the place at the Faculty of Law, which is fantastic. They aren't also charities or not-for-profits, and yet we have wonderful services being provided that provide good learning opportunities for students, also help address some unmet legal needs, and yet they don't nicely fit into the original definition of a CSO. So again, we don't want to hamper that. So when I talked about removing regulatory barriers, we've got this new thing we put into place 2 years ago or 3 years ago. It already needs to be changed, and we recognize that, and we're trying to be nimble to change those definitions.
Thanks, Darcia, for clarifying that and adding that additional info. Erin, what about the Law Foundation and its collaboration efforts?
I just wanted to speak a bit to something that I think we can all be doing a better job of. But first, thank you, Byron, and everyone for all the kudos for the funding provided by the foundation and highlighting FNFAO. It's something we're all really proud of, I think. Yeah, so I think we do a very good job of connecting and communicating and talking about these issues amongst our organizations, but I'm not sure we do a very good job of collectively communicating to the broader public what our access to justice issues and needs are in Manitoba. And I think that's something that we should be focusing on, because without broader public understanding of those needs, there won't be support, and that is really necessary to bring real change. I'm completely using somebody else's observation in bringing this forward, but I think it's a very good observation and needs to be brought forward. So that's all I've got to say on that topic.
Thanks, Erin. Darcia, I know we sort of, I gave you an impromptu question about the regulation of CSOs. Did you have anything to add with respect to collaboration?
Yes, actually, I don't think I've mentioned the Law Library Hub yet. It could have fit into so many other different questions that you've already posed today, but I think that's an example of where we tried, again, with the assistance of the Law Foundation. We're going to keep giving you those plugs, Erin. We asked for a grant to experiment with providing legal information and some limited legal services, initially in the area of family law, right at the courthouse. So it was going to be the law library hub. So we were going to use law students under the supervision of a practicing family law lawyer, and provide services directly to those who are showing up at the courthouse. We were hearing all sorts of stories. Again, sometimes we don't have the best data, but about how many individuals there were wandering around the courthouse, trying to address their legal matters, didn't have a clue what to do in motions court or what have you. And so we thought, well, let's experiment. The Law Society, we're not a service provider traditionally, right? But it's always good to start off with a pilot, and then maybe somebody else can run with it. And just on that, Peter, I know Legal Aid, of course, expanded their guidelines over the years, and you have the agreement to pay program, and then even eventually you expanded that. The model for that, I believe, initially was the Law Society's Family Law Access Center, which was the idea of one of our former CEOs, Alan Feinblatt. And again, the Law Society isn't intended to be a service provider, but on a pilot project basis, Alan came up with the idea, why doesn't, and the benchers said, yes, let's run with this. Why doesn't the Law Society act as a broker and set up kind of almost a match of a list of lawyers who are prepared to provide family law services at a much reduced hourly rate than what they would otherwise charge, to try to help those kind of middle-class individuals who were simply not eligible for legal aid at all, and also couldn't afford the $400 or $500, whatever the rate was of a senior practitioner. And we had, at any given time, hundreds of people on our waiting list. We might only have 30 or 40 people in the program at any given time. And it became really apparent how much of a need there was for that. So Legal Aid ended up taking up the torch. And of course, they could scale up. They are a service provider, the organization. And so when we were able to shut down our program, Legal Aid took it and ran with it and increased access to legal services tenfold in terms of what the Law Society was able to accomplish. But sometimes we have to be bold. And so like the Law Library, it's a pilot project. It will be coming to an end, but we have statistics about it. There is still clearly a need. We tried to be collaborative to make sure we weren't providing duplication of services that the Legal Help Center is providing, tried to address another income level, people who were right at the courthouse. It served a function that if there was a conflict, for example, at the Legal Help Center, they could refer somebody. And actually, just as of the last couple of months, we've been able to expand to providing civil legal services as well, with the assistance of a civil litigator who's supervising some law students. Again, providing them with wonderful experience. It's a win-win, and providing members of the public with additional and much needed legal information and some limited services.
Thanks so much, Darcia. Before I turn it over to the questions in the chat, I just have one more question for all of you. Can you maybe share a high point and a low point, so a pit and a peak, about either access to justice in Manitoba as a whole or access to justice within your organization? Maybe Erin, I'll start with you.
Sure. I'm going to reference the pandemic as a pit, and it's a pit in many ways, but it really exacerbated existing access to justice issues. I think we all know, and it also pulled back the curtain, I think, on many challenges that people are facing on systemic racism and other issues that I don't think were fully seen before the events that took place during the pandemic. So while it's a pit, I think maybe a peak is too strong of a word. I think there's a silver lining there, that now that the curtain has been pulled back and people have a better understanding of some of the issues different groups are facing, that we can use that momentum and build on that public understanding and advance access to justice. And then I'm going to throw a peek in for the foundation, which isn't directly connected to access to justice, but it will be. Interest rates are the highest they've been since 2001. And other than the banks, I think the foundation is the only, or the law foundations are the only organizations that are happy about that, because as I mentioned earlier, our revenues are based on interest earned on lawyers' pooled trust accounts. So we are seeing revenues like we've never seen before. And half of that is provided to legal aid by way of statutory grant. So that should help legal aid address access to justice needs in Manitoba. And with these increased revenues, the foundation is better positioned than ever to make more discretionary grants to advance access to justice to organizations, and also to advance our strategic objectives of increasing access to justice in northern, rural, and remote Manitoba.
Thanks for sharing those, Erin. Darcia, what about you? Are yours the same?
Right. I think the pandemic was certainly a low point for all of us for a number of reasons. Our members were, as we put it, sometimes, drinking from the fire hose. We had to, quickly change and try to help lawyers figure out how they were going to witness wills and everything. And then, of course, the emergency remote witnessing regulation came in, and then ultimately that became permanent. Our heads were spinning. And so again, unfortunately, things like the CSO project that we had just kind of launched kind of got put aside, and necessarily so, because we had other very pressing realities. I think, frankly, in terms of the high point, I'll say our ability to hire Natasha as the province's first access to justice coordinator on a 2-year pilot, and then having an ability to support the Faculty of Law's application to continue that position, just now housing it within the Faculty of Law, where there are additional resources for Natasha to rely upon, including the student power and research, other professors, for example. So I think that's a real high point for us, was that it long seemed to be a need, and it got accomplished, and now she's off and running at the faculty and continuing to do amazing work. So my high point.
Well, thank you. It made my day to be the high. What about you, Kristal?
I have 3 peaks that I wanted to quickly highlight in one pit. On a very general, broad context, I think that we're coming close to a peak. There's going to be a peak in the very near future with regards to access to justice because of what's happening in our law schools, and particularly in the Manitoba Faculty of Law. I think that this has been identified as an area for students to really put a lot of thought into. I think it's going to be considered a competency or a requirement of the profession going forward, that they are in building into their practices a consideration of where they as practicing professionals fit in to ensuring that that Manitobans have access to the legal services and to justice more generally. And so I think we are working towards that. And I think from my experience working with law students in this capacity, I see a real understanding, a real interest, and a real interest in being part of that solution. So I think that that's something that we all have to look forward to in the near future. On a more intermediate level, with respect to law reform agencies, we all of the law reform agencies in Canada, and I believe internationally as well, would have said that 10 years ago we hit a real pit. There was less interest for governments to fund law reform agencies. We weren't seeing the same uptake in our recommendations in terms of legislative implementation that we had seen in the past. And we did see some of our friends in other jurisdictions actually close up shop. The tides have turned with respect to that. I would say that currently law reform agencies throughout Canada are seeing an uptake in their recommendations in terms of implementation, are receiving a higher degree of support financially, as well as from the legal profession. And so I think hopefully that's something that we'll see continue. And then with respect to our Law Reform Commission specifically, we are nearing a peak as well, because we are in the very early stages of a large-scale project that I think that is going to have significant ramifications practically for the administration of law and access to justice. And that is a very large-scale review of the administrative law system or landscape in Manitoba, and particularly an emphasis on judicial review and the judicial review processes that are currently codified. Very little of it is codified, and what other jurisdictions are doing with that regard, and whether Manitoba should be following suit. So I am fairly positive with all of those in all of those regards.
Thanks, Kristal. I'm excited to hear more about that as the project gets going. Peter and Byron, what about from legal aid perspective?
Our pitch, at least my pitch, I think really is that LAM really is designed to be is to provide representative services. That's where we put our concentration in. But that's kind of using the medical example, that means we're the doctor. We step in once there's a broken leg or once there's a heart attack. And the reality is that we need to look more and more at the holistic approach. We need to look at what the problem is before. As lawyers, we talk about Jordan. That's not just timeline, people. It's the principles that go into why we have issues in society. It's poverty, it's education, it's medical facilities. These are things that we do need to address in order to deal with access to justice, because it's that fundamental level of justice. Peaks. Well, the really good thing, and one thing I'm exceptionally proud of over the last 10 years that I've been in senior management, that I've seen legal aid moving, is we have moved very heavily into increasing access. Legal aid used to be available only to those on social assistance, effectively. If you received any kind of income, you just didn't qualify. And as Darcia commented, our agreement to pay program now is helping hundreds of people a year, if not more, who are now getting access to family lawyers that they would never be able to afford any other way. We have made leaps and bounds in moving those sorts of cases forward. We're also working on encouraging more lawyers to take up cases on a legal aid basis, and we're doing that we've increased our guidelines that we pay lawyers as well. We do have and we do have a more robust and a more responsive legal aid program now than we did 15 years ago. And we still have room to grow. In regards to direct peaks, again, I'm going to pass this over to Byron, because I think Pilka's also been doing some really remarkable things.
I'm going to finish on the positive, but I am going to start with the negative. And between 1999 and 2015, I feel like we had a human rights process in Manitoba that we could all be proud of, that was making a difference to individuals and also on systemic human rights matters. Largely because of government cutbacks, that process is just heavily burdened by delays, backlogs, and it's not meeting the needs. And I don't put that on the staff, but I think that's people are losing confidence in the human rights system, and to me that's a low point. On the positive, my positive actually starts with a sad story, which is the between 2005 and 2019, the province of Manitoba clawed back from kids in care close to $340 million. And those are our most vulnerable citizens, 80% of whom were First Nation kids in care, large population of Métis kids in care as well. And in 2020, the government moved to immunize itself from legal challenges against those clawbacks. So one of my highest moments as a lawyer in Manitoba was in May of 2022, when Justice Edmund, then of the Court of King's Queen's Bench, found that the clawbacks were discriminatory against Indigenous kids and kids with disabilities, and also that government's attempts to immunize itself from the rule of law, from the charter, were unconstitutional. And to me, that was such a high point, because it spoke to the highest aspirations we have for our legal system in terms of access to justice and reducing systemic barriers for vulnerable populations. The court speaking up for Indigenous kids in care and speaking very loudly in favor of access to justice. And to me, that's a moment that I will cherish for many years. Thank you.
Thanks, Byron. What a great achievement. I can see why that is a high point for sure. Maybe now I see there's quite a few questions in the Q&A, and I think I even saw one in the chat. So maybe I'll take a moment and we can try and answer these, and I'll direct them to the person who I think they're for. And if someone else wants to step in, then by all means. Darcia, there's a question for you. What were some of the monopoly barriers the Law Society talked about removing, easing, laxing to increase access to justice?
Sorry about that. Had to take my microphone, put it back on. Well, one of them was the CSO rules, where we are permitting legal service deliveries by lawyers, but through other than law firms, through these civil society organizations. That was one of them. We asked the government for act amendments to allow us to create another whole category of legal service providers, limited practitioners. We received those amendments finally about a year and a half ago. They were proclaimed, but we have a lot of work to do in terms of determining, well, what kind of program might be appropriate, training for somebody to be a limited practitioner. What's really needed by Manitobans? Saskatchewan, they had a report that came out in 2015 called the Boncalo report, and they've decided not to kind of holus bolus create a separate category by coming up with a program through a community college, for example. They're doing a limited license pilot project, very similar to what we're calling our sandbox, where they were asking people to come forward. Do you think you can provide certain services? Why do you think you have those competencies, etc.? So the regulatory sandbox is another way that we are literally removing. It's creating a safe place for people who would otherwise be probably accused of practicing the unauthorized practice of law, and saying, you are allowed to provide certain services if we approve of your application within the constraints of this sandbox. So we're not going to write to you and say, cease and desist, stop doing what you're doing. In fact, we're saying, great, tell us how this is going to improve access. And then we'd be happy to literally ignore what would otherwise be rules that would get that person into some difficulty. So those are some ways.
Thanks. And just as a follow-up to that, another attendee is asking, is there a way to find out which organizations have been approved as CSOs or sandbox initiatives, or what are those publicly
They're not
accessible?
yet on the website. There's still only about, I think about 6 at the moment. But that's a work in progress that we're going to be, putting that up on the website. Certainly somebody could always ask us. That's not ideal. We want to put them up on the website so that it's public. And it would also help get the word out to other organizations, frankly. So it's a good question.
Thanks. There's a couple for you, Peter. One that says, getting a legal aid certificate is complicated and requires significant knowledge and time. Is anyone looking at what happens to the certificates and ensuring there are enough lawyers who can take a complicated file? In other words, is anyone making sure that lawyers are picking up the certificates? For example, using something complicated like an appeal on accommodation grounds. Is someone following up to ensure that the lawyers they'd be able to find a lawyer who would be able to accept the certificate?
That's a very good question. And under the system that existed a decade ago, that absolutely was a problem. We would send out a certificate and we assumed whoever we sent the certificate to was going to work on the file. Certificates that are issued by Legal Aid now go to a lawyer. They're sent electronically. It's my running joke that you can never find a criminal lawyer at 5 o'clock at night because that's when all the certificates issue. And you'll see them immediately looking at their cell phones, going through their list of certificates for the day. But the reality is that the certificates are issued to the lawyer. The lawyer then has to review the certificate, review the material that's provided with it, and decide whether or not they can act. Is there a conflict and are they competent? And that is a law society issue. Obviously, you cannot, as a lawyer, take on a case that you are not competent to handle. So when you accept that certificate, you are saying you are competent. I'll come back to the odd exception in a minute. If a lawyer does not respond within 7 days or says, I can't take this certificate, we will then move to the next lawyer in line. So there is a process. There are a few occasions where we simply cannot find a lawyer. And what we will do then, because our panel is limited, is we will go to the client and say, listen, we cannot find a lawyer who's willing to take on your matter. If you find a lawyer, we will issue it to them. If not, then it's simply a matter of we just don't have anyone who is able. We have also had situations where lawyers have taken certificates where we find out from a lawyer, listen, I took this on, and when I looked at it, I thought it was fairly, I could handle this. This has turned into something I cannot handle. It is not uncommon that we will then, again, we'll take the matter back and we will find a new lawyer. So by and large, it is almost never on the client to find the competent lawyer. We do go through those. We do have a process for lawyers to identify where they are comfortable practicing in what areas and what areas they're not, and how they accept certificates. So it's not a situation where a lawyer is ever basically or a client is left to find a lawyer on their own, or where if we indicate that we're able to find someone, we generally can. I hope that answered that question.
Okay, thank you. I think there's another one here for you also about legal aid funding. Should legal aid funding consider costs for necessary services such as daycare or extraordinary housing costs in areas where there's income caps?
Obviously, there is income caps and everything, but I can tell you we do consider daycare costs. That's actually automatically one of the things that we do consider. And where an individual notes that they have X amount of money for daycare, we take that off their gross income, and we do not count that. In regards to extraordinary housing costs, every application is considered individually. So sometimes where there is an extraordinary situation, yes, that will be taken into account and may be reduced. Not always, and it really depends on the situation. But we do consider, absolutely, we do consider daycare, childcare, child support costs. And as we also consider the overall ability of individuals to pay, that may also be a factor that we look at as to whether we make an offer of an agreement to pay or whether we offer a full certificate, where you have someone who is very close to the line, but has significant expenses. It may be a situation where the either myself or the area director should exercise their discretion and extend legal aid to them because of those extraordinary circumstances.
Thanks for that explanation. I think this one was typed in when you were speaking, Byron. So I think this next question is primarily for you, but anyone else feel free to jump in. Often cases of systemic barriers due to special medical needs or vulnerable groups come to the forefront of the courts and the country's attention because of a specific case. Is anyone working on allowing for in-reach by parties who feel that their case is of a special importance to access to justice issues, even through a database that would allow input that could be accumulated through automatic processes that would allow the system to identify outliers?
I'll do my best with this. I do want to just note on the Children's Special Allowance case, there were 3 incredible legal teams involved. So our team, along with Raven Law, was one, DD West, and also Cochrane Saxberg. So I just want to make sure the credit goes to the court, but it wasn't just us involved. In terms of this specific question, PILC did a major engagement back in 2021, and that involved both community meetings with I think over 75 community organizations. We also did follow-up. Anyone who chose to could also participate in a qualitative survey, and we did follow-up meetings with those groups. So speaking purely from the Public Interest Law Service, there are some relatively regular efforts to engage with the community. Also, during the course of any year, we'll meet with a variety of community organizations. I'm not aware of any database like this, and I would concur totally that we could do a better job both of identifying these systemic barriers, but also, I think, as Erin has pointed out, communicating them. And I think we're probably at fault as part of the system for that as well. Our report, I've been frantically looking up to see whether I could get a copy of our 2021 engagement report. I'll provide it to you after the event, Natasha, and we could certainly share that, and that'll give people a sample of what folks are saying in 2021. Thank you.
Thanks, Byron. I think that the next question is for you, Darcia. Should ethics complaints be held to the openness requirements of adjudicative tribunals, and should complainants be allowed to present their claims in person? Oh, you're
because I'm wondering if the question is directed to those suggestions improving access. I'm not sure. It's not to legal services. It's a complainant. Our processes have actually progressively become more and more and more open. I'm happy to say that all of our decisions are posted online. People can come and watch the hearings. Sometimes we have reporters who come and sit in because they want to report on a case. Complainants, if they have difficulty submitting a complaint in writing, we have staff, lawyers and a paralegal who will assist in communicating the complaint. So we certainly do have people who have sometimes literally come down in person, and we've helped them articulate what their concerns are. So I think to the extent that we can, we have some legislative constraints that are there for a reason. For example, if there's a complaint and some member of the public just wants to know if there is a complaint about a lawyer that's currently under investigation, well, that complaint may be dismissed as being without merit. And so, you know, would it be fair to put up the fact that there's a complaint about a particular lawyer when ultimately we might even say the lawyer doesn't even have to respond, because maybe the person's complaining about the judge's decision and not maybe understanding our jurisdiction, and that their remedies are maybe to appeal, etc. So sometimes cases lawyers aren't even asked to respond. When they are, their response can be considered completely reasonable. So from a fairness perspective, that's why we don't just post everybody's complaints history on our website, but all of the decisions are there, the discipline case digests, and not just digests, the full decisions now are posted, not summaries.
Thanks, Darcia. And I think the last question, any of you can take a crack at. I think it applies to all of you. After 10 years, do we have an ability to identify gaps in access that are not being addressed? And the second part of the question is, how do we address newcomer needs, which combine sometimes similar but sometimes unique concerns?
Could I jump in just for a quick second? And hi, Anita. I'm not sure we have such a system. I do know that there was a really interesting report called Justice Stops Here. Alison Fensky, who's now at the Robson Hall, was one of the co-authors on it. And in that report, they did recommend some periodic surveying of Manitobans for access to justice issues. I don't know if that's been done. I'll just say that I thought that was a really interesting recommendation. Maybe Natasha is already totally on top of that, but I'll just say that I thought that was a valuable recommendation. I'm not sure if it's been acted on.
I can
Not-
jump in. Sorry.
I just want to
so-
say I put that Allison's report in the chat for anyone who wanted to read it, Byron.
I just wanted to add that the Manitoba Law Foundation did have Prairie Research Associates conduct a survey of legal needs in the areas of civil and family legal services in Manitoba, mirroring what was done nationally. To Anita's question, in terms of newcomer needs, I think one of the challenges that we identified in the report for that should be coming out soon, but one of the challenges we identified in conducting a survey in the way that we did, which was by telephone and email, was that how do you capture the needs of newcomers who may not necessarily speak English and aren't able to respond to a telephone or email survey. So I don't have answers for Anita, and Anita sits on our board, so she's aware of this gap, but I would love to hear what everyone else on the panel has to say on this.
It's an excellent question. The Law Society, when we did some engagement with community frontline workers in different organizations about 1.5 years ago, Natasha, you were still here. We actually had, over the course of 2 days, 2 sessions where we met with representatives from between 30 to 40 organizations to get their frontline opinions about, and these were a lot of the organizations representing the most vulnerable people out there, and saying, we want to hear from you. What are their legal needs? And get their thoughts on whether this limited practitioner designation, if somebody had that kind of a designation, would that actually help their clients? And interesting, we heard from them that actually trusted community intermediaries would be perhaps a better way to go, that they questioned whether ultimately their clients would have funds available to pay, because presumably somebody who's had the training to be a limited practitioner would want some form of compensation, maybe not as much as a lawyer, but maybe $75 an hour, and that they said their clients would not be in a position to pay for that anyway. And could somebody please train them to provide some additional services? And sometimes they already were providing services, as I said, that may already be crossing the line into what we would otherwise call the unauthorized practice of law. But again, if it's not work that lawyers are willing to do, and there is a crisis and a need, again, it's a tension. The Law Society is supposed to be worrying about the delivery of legal services by competent individuals, but also always acting in the public interest. And it's that balancing act. Is it in the public interest that it always be delivered by lawyers? No, but can just anybody offer legal services? Again, I don't think so. So it's a tension, but that's a great question, Anita. We tried to get some of that directly from these consultations. We're trying to do a better job of consulting with the public. And I hope that we're on a new pathway there.
I might just add that about a year ago, just over, Gerard Kennedy, sort of with my behind the scenes assistant, surveyed the profession in terms of asking about their perception of gaps, and that paper with the data collected from that, we've finished a rough draft of the paper. It now will start the peer review process, but it's sort of the first step, and from that I hope it informs the work that we might do in terms of next steps in identifying gaps. I think there are common themes that come out of these reports, and so I think we definitely could do better with data collection, and stay tuned, because it's definitely one of my priorities for the next short while, for sure. I'm looking at the time, it's 1:59. So, and I think I got to every question, I think. I don't see any that I've missed. Oh, Erin, the last question that I just see you can quickly answer. Your report, that's not ready yet, but will be publicly available soon. Okay. So when you registered for this event, you would have done so on manitoba-access-to-justice.ca. I'm thinking maybe, Erin, when that's done, I can maybe share a link to your report through that site potentially.
Absolutely.
Okay, so stay tuned for when that's done. We'll be able to share it. But with that, I just wanted to thank you all for spending the last 2 hours with me chatting about this topic. And I'm excited to hear all of the work that's been done the last 10 years, but also the work on the horizon and the things to look forward to. And I'm hopeful we can check in again. Hopefully not in 10 years from now, maybe in a couple, and see where we're at that point. But thanks again. And thanks to all of you that tuned in for the afternoon for this event. There's still 2 more Access to Justice Week events on Thursday and Friday, if those are of interest to you. And yeah, thanks to the Law Society for helping behind the scenes with this, and to my RA April, who also helped with putting this together. And yeah, we'll send out the recording link in a week or so. Thanks, everyone.